Amy Barrett support the radical agenda of the religious right? A reprint from my blog post https://sansculot1789 blogspot.com/2020/09/will Amy Coney Barrett support radical.html. The first thing we need to consider about Amy Coney Barrett is the hypocrisy and sophistry surrounding her nomination, in which she has shown herself to be a willing participant. In 2016, Barrett, then a law professor, defended the Republicans' decision to deny Merrick Garland vote or even a hearing. In a standing ovation to raw power, Barrett said, "So I think in sum the President has the power to nominate and the Senate has the power to act or not, and I don't think either one of them can claim there's a rule governing one way or the other. In the first place, this is not what the Senate Republicans said in 2016. Their position then was, in an election year, the voters should decide. The Republicans had the votes to deep six Garland in the Judiciary Committee and on the floor of the Senate. They even had available to them at that time the filibuster they would then have had to take, on an individual senator basis, responsibility for their failure to confirm a qualified nominee. Next, there is, to my mind, the curious question as to why President Trump nominated Barrett instead of Barbara Lagoa, the Florida Cuban American. There are all sorts of reasons, some of them valid, as to why Trump might prefer Barrett to Lagoa. Number one is the possibility that Lagoa might not meet Senator Josh Hawley's litmus test on Roe v. Wade. Another is Barrett's impeccable conservative credentials. However, we know that Donald Trump has never made a decision that was not in the best interests of Donald Trump. If the president loses Florida's electoral votes, the game is up. He may have a small lead, but polling is still too close to call. So, why not pick Lagoa and cement his standing in Florida? My guess is that Trump knows he has Governor DeSantis and the Florida legislature in his pocket. Constitutional scholar Lawrence Tribe has pointed out that the Republican scheme to steal the election by having Republican state legislatures select presidential electors instead of the people. Tribe has pointed out that governors can veto such an action like any other legislation. This will not happen in Florida. If Trump loses the popular vote in Florida, he will declare mail-in ballots fraudulent, and the Florida legislature plus DeSantis will hand him the electoral votes. Finally, we consider fundamental questions concerning Amy Barrett, which she probably won't answer and may not even be asked. Will Amy Barrett interpret the Constitution using natural law based on biblical revelation? Natural law, Latin, is naturale, lex naturalis, is a system of law that purports to be based on values intrinsic to human nature that can be deduced and applied independent of positive law, the enacted laws of a state or society. According to natural law theory, all people have inherent rights, conferred not by act of legislation but by God, nature, or reason. 1. That the meaning of law is such that its content cannot be determined except by reference to moral principles. These meanings can either oppose or complement each other, although they share the common traits that they rely on inherence as opposed to design in finding just laws. Wikipedia. Nothing wrong with basing law on morality, but my problem with the above paragraph paragraph is the assertion that just law cannot be found by design. Natural law advocates set up a false Manichaean dichotomy between natural law and positivist, social contract majoritarian law. The reality is there is no saint, enlightened individual or text that will tell us what is or is not just. Sometimes legislators will get it wrong and the error will be evident only after the fact. In a prior post I offered a partial review of Genuelis, the legal basis for a moral constitution. A guide for Christians to understand America's constitutional crisis. Genuelis, it must be emphasized, is a professor of law and a legal advisor to President Trump. Ellis argues that law must be based on divine law, which she equates with biblical revelation. In particular, revelation in the New Testament, divine law, supported by biblical truth, encompasses the whole truth of reality. General revelation. As Schaeffer said, Christianity is not a series of truths in the plural, but rather truth spelled with a capital biblical T. Truth about total reality, not just about religious things. Biblical Christianity is truth concerning total reality and the intellectual holding of that total truth and then living in the light of that truth. Ellis is flushing separation of church and state down the drain, but she denies there is such a thing as we have come to understand it. The secular narrative shrewdly cuts off the U.S. Constitution from its source of authority and its historical context and then reinterprets its concepts to support their humanistic conclusions. Genuelis attempts to build the case that there can be no morality without divine revelation and that in this regard Christianity is truth with a capital T. Her case is based in large part on a radical interpretation of the First Amendment which rejects the usual notion of separation of church and state. The text of the amendment does not in fact include this phrase. The relevant portion of the First Amendment reads as follows: Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof. Ellis argues that the above does not mandate the separation of church and state. Her interpretation is based on a bizarre extension of federalism in which the federal government, the states and religion have overlapping but separate domains. Interestingly, compilations I have of Supreme Court decisions on this matter are entitled Separation of Church and State, Supreme Court Decisions and Separation of Church and State, Supreme Court Dissents. Robert Dittmer. Obviously, Ellis' views are several miles from the ballpark. Ellis' main thesis is that the only alternative to divine revelation as a basis for moral law is an amoral contract theory of society which she proceeds to caricature and distort. Essentially, her theory is that a society without a foundation in divine revelation must resemble the young men in Alfred Hitchcock's movie Rope, where murder may be indulged in to demonstrate one's freedom. Ellis is not alone in her efforts to proselytize a radical biblical theocracy. Note the recent speech by Attorney General William Barr. https://www.justice.gov/opa/speech/Attorney General William P. Barr delivers remarks. Law School and DeNicola Center Ethics. Relevant portions of Barr's speech include 1. Instead, Social order must flow up from the people themselves, freely obeying the dictates of inwardly possessed and commonly shared moral values, and to control willful human beings, with an infinite capacity to rationalize. Those moral values must rest on authority independent of men's will. They must flow from a transcendent supreme being. In short, in the framers' view, free government was only suitable and sustainable for a religious people, a people who recognized that there was a transcendent moral order antecedent to both the state and man-made law, and who had the discipline to control themselves according to those enduring principles, too. But they also include the guidance of natural law, a real, transcendent moral order which flows from God's eternal law, the divine wisdom by which the whole of creation is ordered. The eternal law is impressed upon, and reflected in, all created things. Modern secularists dismiss this idea of morality as otherworldly superstition imposed by a killjoy clergy. In fact, Judeo-Christian moral standards are the ultimate utilitarian rules for human conduct. 3. What we call values today are really nothing more than mere sentimentality, still drawing on the vapor trails of Christianity. A decidedly contrary view was expressed by the philosopher Bertrand Russell in an essay published under the title Why I Am Not a Christian. That is the idea that we should all be wicked if we did not hold to the Christian religion. It seems to me that the people who have held to it have been for the most part extremely wicked. You find this curious fact, that the more intense has been the religion of any period, and the more profound has been the dogmatic belief, the greater has been the cruelty and the worse has been the state of affairs. In the so-called ages of faith, where men really did believe the Christian religion in all its completeness, there was the Inquisition with all its tortures. There were millions of unfortunate women burned as witches, and there was every kind of cruelty practiced upon all sorts of people in the name of religion. I might dismiss Jenny Ellis as a nut, her erudition and legal credentials notwithstanding. However, the similarity of her ideas to that of the Attorney General of the United States requires they be taken seriously. The agenda of the religious writers represented by Ellis and Barr is as radical as that of communism, which would establish a socialist utopia. In theory, I find neither agenda in the least bit appealing, so the questions I would ask Amy Barrett are these. 1. Do you believe that just laws cannot be made by design, including trial and error? Another way of putting this is that just laws are discoverable but cannot be constructed. An affirmative answer to this question must entail a belief in natural law. 2. Do you believe that law-making must be based on natural law, based in turn on biblical revelation, if only discoverable? Natural law, as opposed to constructed law, is legitimate, and discoverable law need not be based on divine revelation. On what would you base it on? If Amy Barrett has radical notions on the law and its relation to religion, we need to know this prior to a vote on her confirmation. The Republican majorities in the Senate and on the Supreme Court must not be allowed to establish a Judeo-Christian theocracy by stealth.